Welcome back to Dumb Defenses, where we're going around the world to bring you all really weird cases. Some exciting news. We actually have an email address now. So if you have any questions or have a case that you want us to cover, just email us at dumbdefensespodcast@gmail.com and maybe we'll get to you on a future episode.
Mom, you can just text me.
That works too. So I realized that we have not been actually introducing ourselves at the beginning of this. So I'm Frankie.
I'm
And
Judah.
there we go.
We're both lawyers.
We are both lawyers. We're both public defenders. We are both wildly neurodivergent. And
We're both trans.
yeah, and this is a really good excuse for us to actually like hang out on a weekly basis because we've been failing at that because we're both wildly neurodivergent.
Yeah, and we're both really busy. Okay. Yeah, but we're gonna talk. We're gonna nerd up. But we're already nerdy. This is just an extension of conversations that we already have.
Exactly.
And this week, because we've got a format now, and it only
Yes.
took 3 weeks because we both have ADHD to develop a format. So we're
Yep.
going to be doing one less serious, more fun, weird case.
Yep.
And then like a serious, maybe kind of historical, in-depth case.
Yep.
All right,
So
Frank, you're up first.
I am up first. So this case, this is actually going to be a little bit of a different format for my cases because this is one where all I could find were news reportings. I could not actually find the text of the case. So I did a little bit of a deep dive into like the court structure as opposed to the actual case because I couldn't find it. Anyways, this is the case of Serena Kozakura. She was a Japanese pinup model in the early aughts. Allegedly, in November of 2006, it's unclear whether he was like a friend or a boyfriend. She kicked a hole in the door and then allegedly crawled through the hole to get into this dude's apartment because allegedly she was jealous that he was with another woman.
Okay.
So, classic, like, jealous lovers type thing.
This person is a pinup model.
Correct.
So ostensibly, I mean, it doesn't mean much, but this individual could have probably a wide selection of gentlemen.
She could, but for some reason, the allegation was that she was jealous of this dude being with this other chick. But her defense at trial was that he essentially made the hole in the door himself to frame her. She was charged with property damage and lost her job because of that and was essentially convicted based on the testimony of the complaining witness and another friend of theirs. And she was sentenced to 14 months in prison, suspended pending 3 years of good behavior. This is in what in Oregon we would call like a downward departure, where somebody has an amount of prison hanging over their head and then they have to behave themselves. It didn't indicate that it was specifically like a probation, which is what would be required in modern Oregon law, but in Japan it was pending 3 years of good behavior. So she then appealed to Tokyo's high court. So let me take a minute here to sort of back up and go through kind of how Japan lays out their court system because it's a little bit different than ours. So in Japan, there are 5 types of court systems. There are summary courts, family courts, district courts, high courts, and then the Supreme Court. So it's a 3-tiered justice system like ours is. The summary courts handle civil cases under 1.4 million yen. They also handle civil conciliation or demands for payment and low-level criminal offenses.
Like a small claims court,
Kind of, yeah. Kind of like a combination of like a small claims court and a municipal court. Family courts handle all personal status cases, family law cases, adjudication of juvenile cases, and stuff like that. District courts handle mostly civil, criminal, administrative cases, and appeals from cases from summary courts. The criminal cases are generally heard by one judge, but for more serious crimes, they're heard by a panel of 3 judges. There are no juries in Japan. It's all judges.
Oh, interesting. So it's what we would call a bench trial for like everything.
Correct. The district court will either handle criminal cases outright or criminal appeals from summary courts. The high courts are kind of like the mid-level appellate court, and they handle the appeals from the district and family courts and appeals of criminal cases from the summary courts. So from context, It sounds like Ms. Kozakura's case was filed initially in a district court because the appeal was to Tokyo's High Court. The Supreme Court handles all appeals from all the high courts. It has 15 judges with small panels of 5 judges. The cases are first assigned to the 5 judge panels before being sent to the entire bench in the event that there's a constitutional issue. Some procedural stuff that was a little bit interesting compared to how we do things. So in criminal cases, a defendant can be held for up to 72 hours. But if the prosecutor doesn't get a detention warrant, they have to be released after 24 hours. Detention warrants need to be based on probable cause, that the person has no fixed residence, that they may conceal or destroy evidence, or that they are a flight risk. With that detention warrant, they can be held for up to 10 days or 20 days with an extension for the purpose of securing an indictment. There is no pre-indictment bail system, and 3/4 of all cases are dropped pre-indictment. So this is different than our situation. I mean, probable cause to arrest still exists, right? But somebody can...
Tell me what probable cause is.
Probable cause is there's some cause to believe that somebody has committed a crime, right?
It's like a reasonable basis.
It's a
of
reasonable
belief.
basis. Reasonable basis has its own funky definition. If we're talking like percentages, which isn't like legally sound, but it helps people understand, probable cause is like 20%. You got 20% of the proof that you need.
I don't know. I would put it more like 25-30%. Like you've seen
Still.
something, you've heard something.
Right. But it's not like preponderance of the evidence, which is 50% plus 1, more likely than not. Beyond a reasonable doubt is like 99%, right? Clear and convincing evidence is somewhere in between. Again, percentages are not a great way to illustrate this in terms of legal soundness, but for people who are not lawyers, it is a little bit helpful.
Beyond a reasonable doubt, there can be no other reasonable explanation other
Right.
than you did it, and what you did is a crime.
Right. In our system, yes, somebody can be held up to 72 hours prior to being arraigned, but the indictment system is separate. It's only for felonies. So there's a lot of differences here between Japan and Oregon, or, you know, the United States has also similar rules regarding that. In Japan, the defendant can be subject to interrogation without an attorney pre-indictment. That was in place until 2018, but it was in place at the time of this case, so I kept it in my notes. They do get court-appointed attorney if they qualify for it for trial. For certain serious crimes, they can get one pre-indictment if the person remains detained. They can be held up to 60 days pending trial unless a specific 30-day extension is granted. And once they are indicted, they can be bailed out. But like I said, there's no bail pre-indictment. So this is very different than our laws here in America. I'm sure most people are aware of like the Miranda warnings, where you have a right to attorney and to court-appointed attorney if you can't afford that. You know, Gideon v. Wainwright was the originating case of that right. But the fact that you only get an attorney pre-indictment in certain crimes is wild to me.
Except for Japan incarcerates so many fewer,
do.
like
Yeah.
proportionally, percentage-wise,
Right.
than America.
Well,
by-
and 3/4 of all cases are dropped
Yeah.
pre-indictment. Like, they are not holding people over nearly as much as we are.
So, in Japan, it's approximately 33 people for every 100,000 people are incarcerated, which is 0.033%. And in America, it is 0.55%. So
Yeah.
instead of 0.033%. So that's 550 per 100,000 versus 33
Right. Yeah. No,
per
we
100,000.
incarcerate significantly higher percentages of our population than Japan does. And generally, it seems like maybe their prosecutors are more scrupulous about bringing stuff to trial than ours are, partially.
Or
but
they have a better system that's not just like, let's take every mentally ill person that can't get services and put them in jail.
yeah,
And if you'd
there's
like to
that.
hear more about this, you can talk to either Frankie or myself anytime any place.
We have opinions.
I've got a solid 6 hours on this.
Yep. So, Japan does not have jury trials. All trials are in front of judges, and there are trials even if you plead guilty, because the prosecutor has to present corroborating evidence even if there's a guilty plea. For minor cases, a single judge will preside, and for higher level cases, there's a 3-judge panel.
Okay, kind of like an appellate review almost.
Yeah, but it's just
no
because it's a more serious case. It would still be at the trial level. For certain very serious cases, we're talking like murder, stuff like that, there are lay judges that will hear the case, and that judicial panel will be 6 lay judges and 3 professional judges working together. They will conduct the public investigation of the evidence and render a verdict. So that's like quasi a jury trial, but they are called lay judges, and they work with professional judges to come to their verdict. If there is any reasonable doubt, then the judges must render a not guilty verdict. And if you're found not guilty, you are compensated for the time that you did in custody. This is huge. This is not a thing that happens here. In order to get compensated for being wrongfully incarcerated here, it is a huge lift and very, very difficult to get.
It's extremely difficult. If you're wrongfully convicted, you pretty much have to show that the state withheld evidence or engaged in some wrongdoing.
They had to be engaging in unlawful conduct, essentially.
And you have a really limited amount of time, and the compensation per year of wrongful conviction in the States is super low.
Right. If the prosecution appeals, you can be detained until the next trial date. For minor offenses, you could get a suspended sentence for up to 5 years. If you can get convicted of something while on that suspended sentence, you'll serve both the suspended sentence and the sentence for the new crime. That's similar to here with any sort of probationary sentence. A defendant has a right to a retrial after a guilty verdict if new evidence is found. We have that right as well, but it is much harder to get.
Well, it's not just if new evidence is found. You have to establish prior to a new trial being granted that the new evidence
would have changed the outcome.
Could have changed the outcome.
Yeah.
And could not have been located
right
in the initial proceedings. It's very ugly.
Okay. The appeals courts, we're talking about the high courts here. If the defendant appeals, the sentence cannot increase on retrial, but if the prosecution appeals, it could. If they're imprisoned and file an appeal, they are held in the facility closest to the high court hearing it. So there are obviously fewer high courts than there are summary courts or district courts. And so if you are appealing something, you could actually be moved to a facility that's closer to the court that's hearing the case for convenience. Okay. The appellate court reviews the written record of what happened in the trial court. They have a hearing. They hear written and oral arguments of the parties. That sounds familiar to anybody familiar with the appellate process here. The difference is, in some instances, they may request additional evidence to make a better decision.
And we're stuck here with what you got. What you have is what you have. We're not introducing new shit.
We are stuck here not only with the record of the evidence as it is, but unless you specifically request de novo review, you are also...
De novo means that the court is appealing... is doing a more thorough review, like it's of fresh, of new.
Right. It's of new in terms of the findings of fact, right?
Yeah.
Because there's the evidence, the record of the evidence, the testimony, the exhibit, stuff like that. And then the trial court will make findings of fact, or the jury will make findings of fact. And generally, the Court of Appeals and the Supreme Court are locked into those findings of fact. If somebody requests de novo review, which is not necessarily granted if it's requested, then the court can dig a little bit more into the record and the testimony and the exhibits and make their own findings of fact. That is very rare.
Yeah, it's exceptional. I can't tell you how many cases I've sent up on appeal, and I have had no cases of the Oregon Court of Appeals granting de novo review. 0 times.
It's very, very rare. It used to be more common in like dependency cases, but even then, it's super rare.
That is my job. That is most of my job. Dependency cases is children and families involved in the foster care system, essentially. Yep. People's parental rights getting terminated and families being permanently torn apart by the justice system. And I have sent every single genuinely contested termination of parental rights I've ever lost to the Court of Appeals. Some of them with very good reason. Never had it. Yeah. So not only are we imprisoning people, but we're permanently tearing families apart. Anyway, yes. Please proceed.
The High Court can then either affirm or reverse the decision below. If they reverse, there would either be a procedural or substantial irregularities in the case below, or there was not sufficient evidence for the conviction. In either case, a remand for retrial, or they could just fashion their own remedy. Like, they could make a rule and say, this is the rule now, and this is how we're going to resolve this case, and then send it down and tell the lower court, this is what you have to do.
I always think remands are dumb. Because it's like, if you're ordering the lower court to do something, the higher court should just do it instead of just delaying for further proceedings. Because I've had things remanded to lower court, and then you're waiting to get back into court, and then you're discussing the tuning of the just higher court. You
just do the thing.
Just do the thing. Yeah. And they don't. So like, oh, we're going to order the lower court to reverse this. Great. That means that this person who is still in prison has to wait, not just for this judgment to be recorded, but after it's recorded, then to schedule and get back into lower court. So it's delaying actual remedies by months.
Because the appellate rules have a 45-day delay between decision and publishing to a remand, because there's the potential that the person could appeal it to the Supreme Court, which isn't a guaranteed appeal the way the appellate court is, because they get to decide what they want to hear.
And the Supreme Court takes precious few cases. I've never had one of my cases go to the Supreme Court. And I tell you what, Frank, I appeal all the time.
Oh, I do too. Civil commits. So many on appeal right now.
We're just here like... Appeal.
Yep.
Extremely vulnerable people we work with.
Right. So in Japan, there is the possibility for an appeal to the Supreme Court, but that's only if it's a specific issue with the constitutionality of something, or if the finding at the High Court otherwise conflicts with current Supreme Court case law. The Tokyo High Court, where this case came from, hears appeals from district courts and has original jurisdiction for family court. I wasn't clear why that was a distinction with the Tokyo High Court.
Oh, original jurisdiction for my mother. Because
yes, original jurisdiction means that that's where something can be filed initially. It's the trial level court.
So in this case, these family law cases automatically go to what we think of as the Court of Appeals.
Right. It might be that there's not a district court in that area. I didn't dig into that much of the research. Criminal court appeals will go straight to the high courts, like I said, but other appeals will first go to the district courts if they started in summary court. So that's our little detour into how Japan is different than Oregon. Coming back to where we were, Ms. Kazakura appealed to Tokyo's High Court, which was the appellate court for her area.
Can we pause here to say also, like, this individual is a model of kind of like a sexual variety?
Yes.
Not pornographic, but of a sexual variety.
Swimsuit and pinup, yes.
Yeah. So we also have to understand that, you know, similar to American society, not only is she a lady, sexism, but she's engaged in almost an adjacent form to sex work. Mm-hmm. And so I can imagine that she is suffering from a lot of stigma.
Yep.
Like just existing in society.
Right.
And I want to acknowledge that out loud.
Absolutely. She appealed on the basis of actual innocence. And this was apparently one of the cases where the Tokyo High Court allowed additional evidence in. The hole in the door was 8.5 inches wide.
Okay, so if you're holding a sheet of paper, it's the skinny side.
Yep. Yes, the skinny side of the piece of paper, exactly.
Yeah, because it's 8.5 by 11, so it's like just the skinny side. I have 2 cats and no dogs that could fit through that.
Yep. On top of that, she had a 44-inch bust.
Oh, so she is She has a bosom.
She has quite the bosom, yes.
44 inches is a heck of a bosom.
It really is. The appellate attorney.
That's a backache level of
Yes.
bosom.
Oh, yes, absolutely. I had backaches and I was not that large.
I never like truly measured how big my knockers were before I had them removed, and bless them.
There are these things in law that we call demonstrative exhibits. These are visuals that maybe aren't like photographs or something, but something that is used to show how something happened, or in this case, the size of something.
Like some bosoms.
In order to show the High Court of Tokyo how it is impossible that Ms. Kajikura could have fit through this 8.5-inch hole, he held up a dinner plate.
A dinner plate.
And compared it essentially to her standing next to him.
Is each of her bosoms approximately the size of one dinner plate?
You know, the reporting didn't quite get into that, but it was there to show that her 110 centimeter breasts could not have fit through the door that was the size of a dinner plate.
Okay, yes, I see it. So the dinner plate is 8.5 by 11, and you're trying to say that this individual...
Well, the dinner plate's just 8.5 inches around.
Yeah, 8.5
right?
inches. Not 8 by 11. So 8.5 inches, that there is no possible way that these breasts can make it through this hole.
Right.
And I respect that. I respect the hell out of that defense. That's not a bad defense. This is just a weird case.
It's just a weird case. He also argued that her clothes showed no signs of damage that would be expected from trying to squeeze through the hole, and that her shoes showed no damage from kicking a hole in a wooden door. So all around, just all sorts of stuff that probably should have come up at trial. I don't know why it didn't come up at trial.
Maybe the stigma. Maybe she wasn't believed.
Yeah. But the appellate court heard her and ultimately reversed the case.
Yes, let that lady go.
Yep. So Ms. Kazakura noted that the judges maintained their composure during this entire presentation. She said the judges were very good-mannered as they showed no expressions on their face. I guess they were well-trained. It's hard to talk about boobs with a straight face.
Yeah, it is.
And the Japanese culture is so very respectful and demure, but even so, she noted that, you know, the judges managed to keep a straight face while we're talking about boobs.
Good for them.
They reversed it, saying that there were considerable doubts in the complaining witness's testimony. Japanese media was all over this. Various networks asked her to come on to prove that she couldn't fit through the opening.
That can be demeaning. Let's leave this poor model alone.
So there's actually, I did find, and if I can figure out how to put it in the show notes, I will, one of these videos of her like trying to fit through a hole that was 8.5 inches wide, and her essentially like getting through, getting stuck on her boobs and being like, ah. But she did, at the end of this, in one of her interviews, say, I used to hate my body so much because I thought my bust was too big, but it was definitely my breasts that won for me today, which I thought was really sweet.
Your body is your body.
Yes.
Well, I'm very happy for that outcome. I am just kind of expecting that there was sexism and stigma attached to her as a woman and her as an individual who shows off her body for pictures.
Yep. And it was her testimony that he made the hole himself against the testimony of two men saying that she made the hole. So there was definitely sexism involved and stuff like that. But ultimately, she had an amazing appellate attorney who made the argument that should have been made at the trial level.
Yeah, and believed in her and made these arguments with the opportunity. So I'm going to pause here. I say, first of all, great case.
Yeah,
I enjoyed it. So much. I have a sexuality where I do appreciate the bust.
Mm-hmm. Boobs are distracting.
I mean, I didn't want any, but I like them.
Mm-hmm. They're great on other people.
Yes.
Not on me.
No,
was not a fan.
Mine don't need to go. Well, thank you for the story.
Yes.
Now on to the serious story. We're gonna talk about the Twinkie defense. So, Frankie, would you tell me what you think the Twinkie defense is?
So I actually read into it a little bit when I was researching, so I don't want to cheat. So go ahead.
Um, I am going to say a big thank you to Carol Pogash, who wrote Myth of the Twinkie Defense, the verdict in the Dan White case that wasn't based on his ingestion of junk food.
Yep.
The movie Milk, that's quite a few years old, but it's definitely worth a watch. And The Life and Times of Harvey Milk. So Harvey Milk was a gay man living in San Francisco in the 70s. He owned a camera store, and he was elected to San Francisco's Board of City Supervisors. What we could think about in other places as like city councilors.
Yeah.
There was another city councilor known for his conservatism who murdered Harvey Milk with a gun and also murdered the mayor of San Francisco.
Yeah, this dude had issues.
What most people think of comes from this case. So the murderer is Dan White. Is people think that he presented a defense to get less time saying, oh, I had all this junk food and it was the junk food that made me somehow mentally ill and reduced his sentence. And so I'm going to jump in and describe what diminished capacity is. So we had talked in our last episode about not guilty by the reason of insanity or the insanity defense. Diminished capacity is kind of like a step down from that there was...
It's like GEI light.
Yeah, it is the light version. It is not permissible in a lot of jurisdictions in criminal law. It's really applicable in civil law. You see this come up a lot in probate to say this person, they were aging, they had an age-related condition like dementia that didn't fully incapacitate them, but it influenced their decision to such a degree that the contract that they made or the will that they made isn't valid, isn't what they would have done in their full right mind.
Right. And when in the criminal context, because Oregon does have a separate diminished capacity defense from the guilty except for insanity, which is what we call not guilty by reason of insanity because reasons. Our diminished capacity defense is essentially because of some sort of qualifying mental disorder, you were unable to form the intent to do the thing that you're accused of, right? Because in order to be criminally liable for something, you have to have done the bad thing, the actus reus, this is the Latin term, the bad thing, and also have a culpable mental state, what they call the mens rea, the bad mind. Those two things come together to make criminal culpability. So if you have a qualifying mental disorder that maybe didn't get you to the point of like not understanding that what you were doing was illegal, but did diminish your ability to form intent, then it is a defense in Oregon.
It is available in Oregon. I have used it. I'm sure you have used it.
Yep.
And also, like, not guilty by reason of insanity. If you have any other defense, you're going to use that first. You're not going to use this.
In Oregon, there are some differences as well that, like, if you're found guilty except for insanity, then you're sentenced to the Psychiatric Security Review Board and generally to the state hospital versus a diminished capacity defense is an acquittal.
Yes.
So
that means, hey, you're not having consequences.
Right.
Basically. You're not guilty. In juvenile law, we have... because we don't have guilty or not guilty in juvenile law, so we have not responsible. And there's the Juvenile Psychiatric Security Review Board. So there's kind of parallels that go along. So what people think happened to Dan White, because he wound up getting a significantly reduced sentence. He only received 7 years in prison for the death of 2 people. People think that his defense went and presented that this person was eating a ton of junk food and it specifically Twinkies. They have this idea that it's Twinkies, that it impacted his mental state to such a degree that he could not be found guilty of murder and was instead found guilty of manslaughter. So that is this societal perception. And there is a societal perception that, and we'll dig into this, I'm sure, in future episodes, that he was able to successfully use what's called the gay panic defense.
Yep.
That is that you were somebody, a heterosexual person was so affronted by somebody else's homosexuality or their behavior that they killed the gay person and they could get away with it.
Yep, and that's coming relevant again now because now there's the trans panic that's starting to bubble up, which is
the trans panic
concerning.
defense has been used successfully a number of times
Yep.
in a very shameful way.
Yep.
So Dan White was a city supervisor in San Francisco, and at the time he was working for the fire department, I believe, and fire department or police, one of the two. Also was elected as a city supervisor. You cannot hold two city positions.
Yeah, that sounds like a conflict.
Yeah, at the same time. So he had to resign his other city position that was providing the majority of his salary, and he was just acting as a city supervisor. And I can super empathize with the not getting enough or any money. Our legislators in Oregon are woefully underpaid, which means only independently affluent people can afford to run for office. I'm not here as a representative of the school board. I'm just mentioning I'm on the Corvallis School Board right now. It is a huge time commitment, and we get paid a nothing, not $1.
Yep. I just finished my tenure on the Alcohol Drug Policy Commission, also an unpaid position. Lots of work. We've done really great things.
Yeah.
Also unpaid.
Yes. I mean, just for this elected position where you have to run, and if you have to run for office, that means you have to invest money of your own. It's a huge honor for me to be able to serve the Corvallis School District in this way. But I will also say that I'm only able to do this, period, because I have other ways of supporting myself. And I don't have to worry about things like babysitter bills, transportation bills, that I can handle that on my own.
Right.
So the salary today for this city supervisor position is worth about $50,000 in today's money. And San Francisco is a hugely expensive city today,
Very.
less so then, but still very expensive to live in. And he can't have his other job, his career. So he resigns that career. He's just a city supervisor. It kind of comes to a head where Dan White decides to resign his city supervisor position. There's a lot of political things happening at the time too. So we have the first gay person elected, that's Harvey Milk. We also have the first unwed mother elected as a city supervisor. So there's some really fantastic things happening on a political level and
that are super scandalous at the time.
Super scandalous at the time. Still today, like imagine an unwed mother. Oh my goodness. Somebody parenting on their own. A name that we still know today who was a city supervisor at the time was Dianne Feinstein. And she retired only a few years ago.
Yep.
She was a major liberal and progressive voice at the federal level. That's how we know her. But at the time, okay, so this is the 70s. She is a city supervisor. Well, so he says, I quit, like, I can't do this. It's not enough to support my family. There is a huge back and forth, and there's some votes at the time about raising the wage for city supervisors. It's voted down, and he's resigned. But then he tries to get his job back, and the city supervisors vote no. Hey, we're not. You've resigned. Your resignation was unequivocal. We're not letting you back on as a city supervisor. So he goes and first shoots the mayor of San Francisco in the head and kills him. Makes a beeline for the city supervisor's office. Goes specifically to Harvey Milk. Passes by Dianne Feinstein's office. She actually calls out to him, try and talk to him, and he just passes her by. Says he's got something to do. Asks Harvey Milk.
He's on a mission.
Yeah, asks. He's there to kill Harvey Milk. He's not there to kill any city supervisor in general or anybody who voted against him. He's there to kill Harvey Milk. Asks Harvey Milk to go talk in Harvey Milk's office. Harvey Milk agrees and goes into his office with Dan White, and Dan White shoots him dead. So then comes the trial. Dan White presents a diminished capacity defense based on depression
Yep.
and the stress of the time, and he uses his consumption of junk food as evidence of his condition, not as a
Evidence of the
cause.
depression, not the cause of
Yeah,
it. Yeah.
not the cause of it. And this is formerly like a very conservative kind of health nut, you could describe him, very conscious about his eating. He was known for it. So when he was eating all this junk food, it's a symptom of
Of the depression.
the depression, of the mental health condition, of this diminished capacity defense, not a cause of it. But it was
Right.
like later publicized and understood to be a cause. The other interesting thing is that never ever in the course of the trial were Twinkies mentioned.
Yeah.
But it's known as the Twinkie defense. They
Mhm.
weren't brought up at all. Other things were brought up, Coca-Cola, Ho-Hos, but not Twinkies. Dan White is successful in this defense and receives a mitigated sentence. So when I say mitigated, it means it doesn't mean he was acquitted. It doesn't mean it says, okay, you are not guilty, you are somehow not responsible, but you're responsible to a lesser degree for manslaughter, not for murder. So it goes
Right.
from a mandatory life sentence to 7 years. He serves his 7 years in prison, comes out a year and a half later, he completes suicide, which I think is evidence like he was really depressed.
He was really
but
depressed.
this his being found not guilty of murder was a huge deal at the time and resulted in the white riots. So there was
Mhm.
riots in San Francisco. This is also a really blossoming time, not too long after the Stonewall riots, which were in the
Yep.
very late 60s in New York, the Compton cafeteria riots, which were in California.
Mhm.
And ultimately, as a result of this, you don't have a diminished capacity defense in California.
Yeah.
And that's attributed to this case where this individual kills an icon. And at the time, Harvey Milk wasn't this widespread icon of the gay community like he is today, because he was still making history. He's one of the first openly gay politicians elected ever in the history of anywhere.
Yep.
And he was a very strong proponent of gay rights, was really on the forefront, was really on the cutting edge in a way that would be challenging in today's political climate.
Absolutely.
And he was a really strong, thoughtful, charismatic, dare I say handsome if you see a picture of him, advocate for the queer community, and met an untimely fate. I think it's reasonable to say that his being so openly gay was completely a part of why he was targeted.
Yeah. Well, he was also doing a lot of really good things for citizens in his position as the city
Mhm.
councilor, right?
Yes, he was.
And so that was ruffling feathers of the establishment people as well.
He had this incredible grassroots campaign that I don't think we can underestimate, where the people of his district wanted someone who was like them,
Mhm.
who would stand up for them.
Yep.
And he was that person. He's not coming from an ultra affluent background. He wasn't a very rich man. He did own a shop, but it's not like he was like this very wealthy, owned, multiple stores. And he's concerned with the housing problems, the crime, the police brutality of his district, and did a beautiful job being very brave and saying, like, I'm here for these people and I'm going to work for them. And he really worked hard for them.
Yeah.
During his time as a city supervisor. So still a great role model today.
Absolutely.
And a very untimely end. Who knows how much better the world could be if Harvey Milk wasn't killed.
Mhm.
But we can still say that, Dianne Feinstein, who has very deeply problematic elements, but she really still herself, she was shaped by that moment, and we can see how she was shaped by that moment and how hard she fought even though she was not a member of the LGBTQ plus community,
Right.
throughout her career, she really stood up. And you can see the many, many times that her being in the same building, her working with these people during this time, and her political career progressed significantly because she was appointed as mayor of San Francisco after the mayor's murder.
Yep.
And went on to have a very impressive political career. Also, her minority status, she's a Jewish woman, and that is still a big deal in representation and in politics.
It is. There's all sorts of backlash against various minorities at this point, especially currently, which is terrifying to watch. I live in an area where ICE has come into our courthouse and arrested people, some with valid warrants and some not. So to be a minority back then, to be a minority today, it is scary, and there's a lot going on. To have people who not only are allies, but who are from our own communities stepping up and making the changes that need to be made. Those people are icon. Like Harvey Milk was an icon. And aside from just the horrific way that he was murdered, just imagine what he could have done with the momentum that he had from that grassroots campaign up into the city councilorship, making the moves, doing the thing, how much more he could have accomplished, how much higher in politics he could have come had he not been murdered.
And I mean, because Dianne Feinstein, immediately after this incident, when she was mayor of San Francisco, and she was mayor of San Francisco for quite some time,
Yes.
she was moderate by then standards, especially by San Francisco standards, because she did oppose extending same-sex benefits there in the 70s, early 80s. And thinking about the popularity of Harvey Milk, we don't know if he could have been elected mayor of San Francisco, if that could have been the first city in America way earlier to extend same-sex benefits to city employees.
Right.
Just the huge, tragic loss of this luminary.
Absolutely. In terms of diminished capacity defenses, depression's a little bit of a weird one, to be perfectly honest. Most diminished capacity defenses that I see are because somebody like dissociated from PTSD or have some sort of intellectual disability where they process information like a small child. Things like that are more common that I see with diminished capacity defenses. Depression is a qualifying mental disorder, but it's not one that typically causes somebody to lash out in that way. That's what's strange to me about this one in particular. Not that diminished capacity defenses in and of themselves are strange defenses. I think they're very valid and appropriate when you have somebody who is in that situation. But to have depression be the qualifying mental disorder is a little strange.
I want to say that I think that we obviously evolved culturally in our understanding of mental health.
This is true.
In a sense, this time. And so where I've successfully used a diminished capacity defense is mostly when I'm talking about assaulting a public safety officer and resisting arrest, for the understanding that the person that my client is dealing with is a public safety officer to begin with.
Right.
Dealing with information processing.
And to sort of explain where that's coming from, under Oregon law, there's a mental state that needs to apply to every single element of the charged offense, or there at least has to be what's called criminal negligence, which is the absolute lowest mental state possible. And generally that criminal negligence, in the event that like you're dealing with something that's done intentionally or knowingly, that criminal negligence generally applies to a money amount. So in order to be guilty of assaulting a public safety officer, you have to knowingly or intentionally cause physical injury to somebody you know is a public safety officer.
Is a public safety officer. I think people, well, like when I'm thinking about our audience,
Yep.
Frankie, so you know, I'm thinking only and exclusively about my mother. Hi, Mom. Again, she's going to really enjoy this. So you work with very mentally ill people.
I do.
And I work with children.
Yep.
Many of whom are also very mentally ill. And there is no civil commitment procedure for mentally ill juveniles.
Correct.
And so we're bumping up against these issues constantly. I would say far more frequently than maybe just about any other type of attorney in the entire state. When you're thinking about your own clients and presenting a defense that societally there's this backlash,
Right.
how are you thinking about doing that in a way that is dignified and helpful for the people that you're working with?
I think it's really important to work with the client so that they understand what's going on. I mean, obviously, they have to be fit to proceed. They have to be able to understand the moving parts of the court, what your job is, what the jury's job is, all that kind of stuff, be able to help you in their defense and be able to cooperate with you. That's at base the first thing that you're assessing when you're dealing with somebody who has a severe and persistent mental illness. But assuming that they're fit to proceed, I really work to educate my clients to be able to understand like what the defense is, why we're doing this. And it is in part their choice whether or not they want to put all this out there, right? They have to cooperate with the evaluation. They have to cooperate with the state's evaluation if the state decides to evaluate them also. And that's a lot for somebody to go through.
Yeah.
And so they have to be a full and willing participant in this whole process. And then when presenting it to a jury, you know, it's something that you have to ask when you're doing jury selection, asking people, what is a reason that somebody might not be culpable for something that happened? Why would a kid not be culpable? Why would maybe somebody who has dementia not be culpable? And then you sort of like walk inwards to land on somebody who has mental illness. Stigma is reducing. It's easier to do a mental health defense now than it was 10 years ago because more and more people are talking about it. More and more people are probably going to therapy themselves. But it is a little bit of a tightrope walk to present this evidence because it's going to be awkward to the client. One thing in all of our civil commitment proceedings that the judge frequently says at the end of the proceeding is he thanks the person alleged to have a mental illness for sitting through it because it's really hard listening to people talk about you like you're not in the room.
I think what I want to address briefly is why we're never going to talk about our own clients on here. And I guess I'll start because I brought it up. I want to say that like the reason that I persist in public defense, specifically juvenile public defense, is because I like my clients so much as people. I consider it a true privilege to be working with someone who has been put into such a dehumanizing, vulnerable, hypercritical, confusing system.
Yep.
And to be working alongside them where I'm trying to figure out as best as I can to work with them to reach. So I always talk about my clients, like, let's talk about what your goals are and how we can try and meet your goals, even though I know you do not want to be doing this.
Yep. Yeah, absolutely.
And I could never put them on blast, I guess we could say, because it's easy to like, oh, we're going to read. We're not looking somebody in the eye when we're talking about these other cases, because the depth of somebody's humanity and their experience is such a profound thing. And to have this position where it is a huge privilege, it is also like we do not get paid money, really. And we have tons of clients. Why I keep doing this after almost a decade is I appreciate and respect and love working with the people that I get to work with. And there's nothing that makes me happier professionally than being able to work with a client over the course of sometimes years to help them achieve their outcomes and to elevate the dignity of their human experience and who they are as people in such a brutal system.
Well, and also we are meeting people at their most vulnerable, and specifically when you're working with indigent people who qualify for public defense services, because it's unfortunately harder than it should be to qualify for public defense services in Oregon. that,
I will say, not for kids.
well, kids are presumed to be indigent, but I work with the adult population, and it's harder than it should be to qualify. Essentially, if you own a house, you won't qualify, even if that's the only asset that you have. But we're meeting people who are vulnerable. My caseload is almost exclusively civil commitments, so all of my clients have mental illness. But when I was doing more heavily criminal work, I would say probably 80% of my clients had some sort of substance use disorder and or mental health issue. And so these are very vulnerable people. These are people who are living in poverty and making decisions because they're poor.
Yep.
Very, very few. I don't know that I've encountered anybody on my caseload who is truly evil, the way people imagine a criminal defendant to be. Most people are poor and are dealing with things going on inside their head that other people aren't going to understand, and are acting out because of that, either to perpetuate an addiction or because they don't understand what's going on around them the way that we do. And even if you're dealing with somebody who had a drunk drive, which is like the crime that I've found most people are able to identify with if they are not involved in the criminal legal system. Even something like that, you're dealing with somebody in their most vulnerable position, even if they are not a vulnerable population themselves.
I have had, and you have had, thousands of clients.
Yep.
Actual thousands of clients.
Mm-hmm.
I was licensed in 2017. It's now 2026.
And I was licensed in 2011. I did take 2 years off because I had a little bit of a burnout. I am much better about taking care of myself at this point. I learned my lesson, and, I'm in a firm that is now fighting the state about ethical caseloads.
I also work with adults because I work with parents
Right.
who are involved in the dependency system who have most likely had their children removed by the state. And I will say, of the thousands of people that I've worked with, sometimes in very egregious circumstances,
Mm-hmm.
that I have worked with 2 people who I could say were like traditionally evil. And
But if you look at the science of personality disorders, they're coming around to the fact that even personality disorders, even like antisocial personality disorder, which is kind of like what colloquially people might think of as evil.
Yes.
Personality disorders are based in trauma. They are maladaptive coping mechanisms that have become so ingrained in how you react to things that it becomes part of your personality.
Yes.
So keeping that in mind has helped me give clients a lot of grace if they are dealing with more the personality disorder end of the spectrum versus the qualifying mental disorder end of the spectrum. What used to be in the DSM-4 and DSM-4-TR Axis 1, which was mental health, versus Axis 2, which is personality disorder. DSM-5, DSM-5-TR, everything's a spectrum now, and they no longer have the axes, but I still think of it as Axis 1, Axis 2, because it helps me remember,
Which
where things
category,
are.
like kind of which class we're dealing with.
Right.
Well, I remember when I first started working, a group that I think that I struggled to work with, not because I thought they were evil at all, but because I found it kind of frustrating and repetitive, was individuals with borderline personality disorder.
Yeah, and what's interesting with borderline personality disorder, it is frequently confused or misdiagnosed kind of back and forth as each other with bipolar disorder.
Yes.
They are 2 distinct disorders with very specific symptom sets that require diagnosis, but that doesn't mean that people don't get misdiagnosed, right? And also, borderline personality disorder is one of the more treatable personality disorders. The reason that personality disorders are generally kept out of qualifying mental disorders is because they're not considered treatable, but borderline personality disorder is actually one of the more treatable ones if you use like dialectical behavioral therapy.
There's plenty. We think, there's a public perception like a personality disorder is just what it is, but psychotic personality disorder, which is often misdiagnosed as like schizophrenia.
Right. You can have schizotypal personality features.
Yes. Very treatable.
Very treatable.
Borderline personality disorder is very treatable. But so like for me, confronting my own internalized prejudice, Now I absolutely don't mind at all working with people with borderline personality disorder. The only struggle that I have is there's such strongly self-destructive elements as a feature that my heart hurts for them. Is I had to flip on my head my understanding of how these people operate and why they operate like they do.
Right.
And once you're able to understand them as individuals with a set of symptoms
With the symptoms, yeah.
that are diagnosable, and once I really got to see how dramatically unfun for them this disorder is, and to see how are we successful in working with people with BPD, and it is through consistent empathy and stability,
Yep.
remaining regulated, and trying to create as much as we can a system that's not reactive to negative behaviors when those are coming out as a part of their like cyclical behavior patterns.
Right. And just the consistency. Like,
Yeah.
all of these personality disorders are based in trauma and in how you bonded with your parents as children. The maladaptive coping mechanism aspect of it, like that is developed early in childhood. If you have a consistent and loving parent who shows up all the time, much less likely to develop these kinds of maladaptive coping mechanisms. I teach a whole thing on attachment theory to our clerks. So that is a big old rabbit hole that we could go down at some point, but it is in theory treatable if you can get somebody to believe that you are there consistently for them.
Yes. And it is that community and that thing that the justice system doesn't offer, which is community, love, and support, which you actually see success and people being happier.
There has been some huge backlash with the federal court disallowing additional case types from going to the state hospital to be restored because the state hospital has been out of compliance with getting people there within a week forever.
Like 5 years, right?
Well, I mean, it started in 2001 was when
5 years.
Mink was filed. 2001, not 2021.
Oh, 2000. Sorry, 25 years. I apologize.
Yeah, they've limited essentially property crimes and low-level felonies, and they've limited the number of 180-day extensions for violent felonies. And people are all up in arms that, like, murderers are going to get to go free, blah, blah, blah. Because there's this fundamental misunderstanding that mental illness leads to violence, when in reality, the greater likelihood is that somebody who is mentally ill is going to be the victim of violence.
Oh, and the clients that I've had that have been profoundly mentally ill, it's property crimes. It's things that are arising out of confusion, getting lost.
And I mean, there are times where somebody might do something violent, but they're frequently responding to some sort of internal stimuli and they are unable to overcome it. And they also are just not living in consensus reality. You know, that's like schizophrenia. The schism that we talk about in schizophrenia is a split from consensus reality.
Well, yeah. And most of our clients, period, are not individuals who have committed violent offenses.
Correct.
And of the individuals that we represent who have committed what we consider ultra-violent offenses, I'm thinking like arson in the first degree, assault 2, assault 1, attempted murder, rape 1, rape 2, sodomy 1.
These are all crimes that were determined in, I believe, 94 to require mandatory minimum sentences under what's called ballot measure 11 in Oregon. All of these crimes have a presumptive and minimum sentence of at least 70 months.
70 months. And you can't reduce for good time or for treatment or anything.
It's day for day time. You don't get good time. You don't get programming.
And being higher level... Go ahead.
I was going to say, because locking somebody in a box is going to make them better.
Yes, let's just say that's not going to make them worse. There's evidence of over decades of time that it makes everybody worse.
Even somebody who has no underlying mental disorder, if they are placed in solitary confinement, will develop psychosis.
I have never, ever, and I specialize because I do what's called a waiver type of trial, which means I'm a very highly qualified type of juvenile public defense attorney. I can handle extremely high levels like high levels of ultra-violent crimes. I travel across the state at the state's request because I'm one of not very many people who can handle this type of offense in the state of Oregon, period.
Essentially, kiddos that are charged with Measure 11 offenses, the state can try to what's called waive them into adult court.
Have them tried as adults.
So they are tried as adults and not as children in the juvenile.
And they can
realm.
be sentenced with the adult mandatory minimums, which means they would go from a juvenile facility to an adult facility.
On their 18th birthday.
On their 25th birthday.
Right.
25th birthday.
It's been a while since I did juvenile.
And I do it all the time. So I travel all across the state to do these, what we consider like ultra levels of crime. So I see more of them than even the average juvenile public defense attorney by a lot because I have these qualifications. And 100% of the juveniles that I've worked with who have been alleged to have committed these major offenses have had multiple significant major traumas, not just one, multiple, and have what you were talking about earlier as at least one Axis 1 diagnosis, which is not a personality disorder. Juveniles actually can't be diagnosed with personality disorders.
It's called conduct disorder or something.
There's so many other ways that they call it the pre-personality disorder diagnoses. And adults can't be diagnosed with oppositional defiant disorder, which is a pre-personality disorder, conduct disorder, which that's bullshit. The diagnosis is bullshit.
Yeah.
And getting to know the history and the circumstances and this child, because they are children. They are children, and teenagers are children.
They are children.
They are just tall children, but they are children.
Brains do not fully develop until they are 25.
25.
That's when your whole prefrontal cortex, planning, executive function, all that stuff, that's when that develops.
Yeah, and there's some argument to say that it's actually 28.
Some arguments say it's 28. If somebody has something like
25.
ADHD, then maybe it doesn't ever develop fully.
I've had multiple children on my caseload recently where their behavior is a direct result of both major trauma and input from a psychiatric disorder. And so to think like these kids aren't who you think they are, and they're also not inherently dangerous. I meet alone with these kids all the time, and because I know how to co-regulate, I feel fine about it. And I will do it again tomorrow, and I will do it again tomorrow because that's my job.
Yeah.
They're not restrained.
A lot of
meet alone.
There's a lot of misunderstanding about just mental illness in general, the criminal defense world in general. We run into that daily with our clients. We run into that daily. I do a lot of advising of the younger attorneys about how to work with their clients with mental illness because a lot of them have mental illness. And the numbers are only increasing. That is something that is a legit thing that we have to deal with. Whether or not in the case of the Twinkie defense that was legitimate at that point, it was legitimate enough that it worked for him.
And that person ultimately wound up completing suicide, which is a tragedy. Always. When we lose an individual to suicide, it is always a tragedy. To say like that was really occurring for him. But so next time
I pulled up for next time the Matrix defense.
Ooh. I picked this case on name alone.
And
I have selected the Sweet Fanny Adams case.
Nice. All right. So
I think it'll be a quick one. I think it'll be a good
palate
you
cleanser.
know about Fanny, a quick in and out.
Okay. All right. Thanks for joining us.
Thanks for joining us.
One thing that we've also been neglecting to do is please rate, review, share so that we can grow and get to more people. And again, if you have any questions, thoughts, concerns, or a case that you'd like us to do, go ahead and shoot us an email at dumbdefensespodcast@gmail.com, and we'll catch you next week.
Catch you next week.